Okay, good morning, everyone, and welcome to Wednesday morning's online seminar. Today we are looking at effective delay analysis, the tools and techniques, and this is presented by Richard Silver, Senior Partner. As always, Richard is happy to answer any questions you may have. Please use the Q&A or chat tool in the bottom toolbar there, and he will get to these at the end of the presentation. Alternatively, if there's something you'd like to ask him that you don't want to ask in an open forum, please feel free to use the email address details that you see there on the screen, richardsilver@silverllp.com, and he's happy again to answer these emails from you. Okay, without any further ado, Richard, it's over to you.
Thank you, Julie. Good morning to you all. We're going to deal with one of my favourite topics, delay analysis. You will all be aware that my background is in construction. I was at different times a surveyor, contracts manager, chief surveyor, construction director. But throughout that period, unfortunately, many of the jobs I was involved in did not complete on time. And as is always the case, generally, we didn't accept it was our fault. It must have been somebody else's. And as a consequence, whenever we had a project complete late, we always claimed extensions of time and had some level of success. But no doubt, in retrospect, we could have done better. Having moved on to the legal side, I have been involved over the years in many claims. And again, the parties that I've represented have had some level of success, but they would all probably say they had a greater entitlement, be it the contractor or the employer. And one thing I have seen is that the quality of the records in relation to delay analysis has been, at best, poor. It could have been much easier for parties to claim or to defend claims had better records been kept. And it's that which we're going to hopefully address as part of this lecture now. When one is looking at delay analysis, one needs to determine why the project was delayed. Quite obvious. But in order to do that, you need to start off by determining what was the original intention. What would have happened if nothing went wrong? You need a baseline. And I think that's the important starting point, is what is a program used for? Now, at the beginning of a project, a program is issued, and sometimes it's incorporated into the contract, sometimes it's not. Sometimes it's called a construction program, a contract program, a provisional program, a target program. There are lots and lots of different words for this term program. And I think all too often, the parties do not properly consider what that program is for. And I emphasize this by the fact that when I was running a department, when producing programs, we had more than one. We had a program as the contractor that we issued to the employer. We had a program that we used for the internal management of the works. And we had a separate program, often short term, that we issued to our subcontractors. And the question is why? Well, the answer is that, dare I say, you may be seeking to advance a separate case to the employer and seeking extensions of time to that which you are monitoring progress. You need to consider what your program does and shows should you need to use it as a baseline for extensions of time. Now, when I'm doing this in front of delegates, quite often I get quite a bit of feedback from that and saying, well, you'd say that, Richard, you're a lawyer. But what I put to you is if you are a contractor on a job and it has ended up being late, and your program, if put together in one format, will give you a 5-week extension of time, and put in another format doesn't give you anything, which one do you want? And the answer will always be, you would like the extension of time. So therefore, when producing the program, you should be given consideration as to how it can be used as part of a claim submission in the future. And the same applies to those of you who are employers or act for the employer. Be aware that when a program is being produced and issued to you, there is every chance that it is being used as a baseline for a future claim. And therefore, ideally, you want to get this program before the contract is in place and make sure that you properly review it and that you're happy with it. Which draws me to the next point is, when you've got this program, is it a contract program? As I've said, quite often, parties issue me with what they say is contract programs, and I have to determine whether in fact they are right. So what is a contract program? And if it is a contract, what is the implication? Well, the starting point is if it is a contract program, it should be a contract document. It should be incorporated into the contract, either by a document saying the following are the contract documents, number one, contract program, or when all the documents are put together and signed, it's in there. And if it is, then being a contract program, it has some form of contract effect or implication. But unless the contract says otherwise, all the contract documents should be read when determining the parties' obligations. So you would think, well, I'm looking at the program, it's a contract document, that must be the program to which they're going to work. Well, the problem is if it is in conflict in relation to other provisions within the contract. So if the contract says, for example, the contractor shall carry out the works in accordance with the contract program, and nothing else is said, then that is the obligation. But what happens if there is a provision for extensions of time, but the extensions of time only applies to the end date? Then all the periods within that program, if they're delayed, are you entitled to an extension of time? Or if you fail to complete by the date, are you entitled to be levied damages? This is often the issue that arises with subcontractors. Subcontractors given an end date and also a program, and the subcontractor doesn't necessarily perform as they should do, and following trades are delayed, and the contractor then seeks to levy damages against the subcontractor. There is much case law on this, and it is quite clear that unless the contract is very clearly drafted, which I'm afraid to say more often than not it is not, the subcontractor is given the whole of the contract period in which to complete the works. In other words, he only has one obligation: to carry out and complete the works by the completion date, and if he should so fail, then there may be a liability to damages for the costs incurred by the contractor as a result of the breach. One can see this must be the natural conclusion because there is no other provision in the contract for extending the periods in the contract program. Now, DOM 1, the new JCT subcontract, actually provides for periods. It doesn't provide for a program, it provides for a period. But when I see these completed, nearly always, they are not broken down into loads of activities. At the very best, they're broken down into 2 or 3 elements, which means only those 2 or 3 elements have a contractual obligation. But be mindful, if you break them down into 3 elements, then your extension of time award should be given against those 3 elements. And there may also be claims for loss and expense for delays to those 3 elements. They're treated as separate sections. So if you are involved in a job and you're producing a program, starting point is to determine what is the obligation with regards to programming, both as to the imposition upon you and the issue of. Now, I would stress this is particularly the case under the NEC, because under the NEC, we have an accepted program. And if you read through the contract, you will see that at the very least, you should be issuing a revised program each month, and that each program supersedes the previous one. And as we'll identify in a moment, it is the program, not what is actually happening, that determines your extension of time entitlement. Okay, so we've identified the importance of the program. If you're a contractor, what should you show on that program? And if you're an employer, what should you be looking out for? Well, I would suggest to you that if you're producing a program, you want most of the activities starting as early as possible. Number one is it enables you to carry out and complete the works as quickly as possible. But more importantly, what it does is it places an obligation upon the employer to allow you to start by those dates. And should the employer fail to do so, then you have a potential claim for an extension of time. So, for example, if you're looking at a particular element of works where there is a lack of information and you're showing it's going to start in week 2, and they don't give you the information early enough, then you can claim an extension of time. And if the program substantiates that entitlement, you're likely to be entitled to it. So on the programs, you want to show the earliest start dates. But the problem is if you have a program that sets everything finishing as early as possible, you might not comply with it. You'll therefore be shown to be in your own culpable delay, and you'll know the sort of arguments that will come back to you. So to try and show that you are not in delay, it is quite often in your best interest as a contractor to show the latest finish dates. And now those of you who are consultants would often see these programs with massive long bars against every activity, starting really early and finishing each very late, and each overlaying the others. Why do contractors do that? Well, you now know. So my advice to you as consultants is that when you deal with, for example, the JCT forms of contract, is to put bespoke provisions in as to what is the nature of program that is required to be issued, what information should be included upon it, when it should be revised, so on and so forth. And indeed, you'll find those very nature of provisions within the NEC. And I strongly suggest to you that's something you should be looking to do. It's my experience that we have within many contracts provisional sums, and all too often they're used excessively. I have actually seen a whole section being covered by a provisional sum. If ever there was a disaster in the making, that was it. Now, under the SMM7, by way of example, we have provisional sums, and there are 2 of them, defined and undefined. And the separation between these 2 definitions is dependent upon the level of information that is to be provided by the employer as part of the contract documents. If you don't provide sufficient information as set down in SMM7, it is therefore thought that the contractor doesn't really know what is the nature of works to be undertaken, and hence it's undefined. If it is undefined, the contractor is deemed not to have allowed for programming, planning, and preliminaries. In other words, any expenditure against that undefined provisional sum gives the contractor both a potential entitlement to additional time and loss and expense. Now, in seeking to overcome that problem, it is quite common for elements of work which clearly are not sufficiently defined in the contract documents to nevertheless be called defined provisional sums, with an attempt to negate a contractor's claim. Now, unfortunately, that is unlikely to be successful. Within the JCT, where there is a B of Q, it says it's to be measured in accordance with SMM7 in the contract documents. But quite clearly it hasn't, because it doesn't comply with SMM7 because there isn't sufficient information in the contract documents. We therefore have a conflict. We have a contract that says the B of Q should be measured in accordance with SMM7, and we have a B of Q that says it doesn't. Well, you'll be aware that, as I said before, the contract documents are to be read as a whole. However, if there is a bespoke provision in the contract, or a provision within the contract which deals with this necessary issue, then it will apply. And the JCT does. It says that where there is any conflict between the contract and any other document, the contract shall prevail, with effect that it will constitute a variation in changing the defined provisional sum to an undefined provisional sum. So be warned. So for contractors where there are undefined provisional sums, it is quite obvious you should not be showing them on your program. I've seen contractors doing this. The actual contract is saying you have not allowed for programming the undefined provisional sum at all. But the contractor's shown them on their program, and therefore if they are expended, that's what they've allowed. It's on their program. You are giving away extensions of time. Where they are defined provisional sums, I would suggest that A, you should be putting them as early as possible in the program, and B, showing them as short as possible. It follows that where the provisional sums are issued late, instructions on their expenditure, you have a claim for late instructions. Moreover, when the provisional sum is expended and the period you are going to need to carry out that work is greater than you reasonably allowed in your program, again, you have a potential extension of time. The next thing is access, and this is surprisingly a common problem, particularly on airports, rail projects, schools, universities, the list goes on. It is a particular problem when dealing with subcontractors. All contracts must provide for when you are to start the works. Unless stated otherwise, if it says you start on one day, that's when you are allowed to have access to everywhere. Now, NEC recognises that access may not be given to all areas and provides for different access dates. JCT really only deals with different access dates when there are separate sections. But the point is that on the date that possession is meant to be given to the contractor can expect possession of that area and claim an extension of time if they're not given full and proper possession. Now, under the JCT, we have the potential for the deferment of possession, but it only allows for a period of 6 weeks deferment. Where there is a deferment of more than 6 weeks, the contract mechanism for time is, or effectively fouls, and time is rendered at large, as is damages, a surprising consequence. So in other words, where we've got a date in the contract for possession and that does not occur, the contractor is entitled to an extension of time of up to 6 weeks. But if the actual delay caused is greater than 6 weeks, for example, 7, the employer the architect is unable to award a 7 weeks extension of time, but the contractor has been delayed by 7 weeks and is only awarded 6. They're being penalised. As we know, in English law, you cannot have a penalty clause, so the contract fails. So be mindful of when you require access. Indeed, I've been involved in jobs where we are behind and we're entitled to no extension of time. But what we've identified is areas that cannot be given to us to carry out the works. So we've asked for them. We've shown a revised program, which is more than reasonable, and we've said this is what access we want to catch up the lost time. Because the other party is unable to do it, we are thereby entitled to an extension of time based upon this revised program we've issued. Now, what we've identified so far is the importance of issuing and keeping up-to-date programs. As I said at the outset, my background is in construction. I remember, albeit it's probably some 30 years ago, when I was first on a building site, I was told by the contracts manager a basic rule. The rule was you issue at the start of the job a program and you do not revise it. You continue to monitor against it at all times. And the question is that right? And the answer is no. There is basically 2 reasons when you should always revise your program to best suit your position. Now, you may revise it at other times and you may need to revise it in accordance with the contract conditions. But as a general rule, where you are in front of program, you should revise your program to show yourself being on program. Why? Well, put simply, let's just say that you're on a project and it's halfway through and you are 1 week in front of program. You are then delayed by 1 week and claim an extension of time. What is the common answer you get back? The answer is, well, you've not been delayed. You had 1 week of float in your program because you're 1 week in front, and therefore you have no entitlement. To avoid those arguments being thrown at you, simply show your program being on time. Now, the reverse equally applies. Let's say you're halfway through a program, you are 1 week behind. There is then a 1 week delay. What is the argument? There are concurrent delays. Yours one occurred first, so it is subsuming the subsequent one. You have no entitlement to extension of time. Indeed, I have a client who is asking that very same question. They have a situation where there is a known contractor's delay of some 10 weeks. During the 10 weeks post-completion, when the contractor is in delay, the employer is issuing a load of additional works, but they are not ultimately delaying completion. Is the contractor entitled to an extension of time? No. So in summary, you should revise your program so that you are always on time if you possibly can, unless you are blaming someone else and hence showing that delay. One issue that arose there in part is the issue of float, and I'm going to address it. Who owns the float? Now, what I've done here is to show a base program. This shows very simply 3 activities, with there being a period of float between the end of activity 2 and the beginning of activity 3. What I've then done is to add in green what actually happens. And what you can see is that activity 2 finishes late and there is a delay. And that delay is caused by an employer's event. It is an event for which the employer is responsible. But what entitlement of extension of time is the contractor entitled to? Well, the answer is none, because there has been no delay to the contract completion date or to the program, because activity 3 is able to start on time as programmed. Activity 3 then carries on but finishes late, and ultimately the contract finishes late because it is a delay caused by the contractor. The contractor is now liable for liquidated damages, and hopefully you will all agree. I will now give you a different scenario. Activity 2 is delayed for an event for which the contractor is responsible, but activity 3 is able to start on time. Activity 3 then finishes late because of an employer's culpable delay, and the contractor is entitled to both extensions of time and loss and expense. What's the difference between my 2 scenarios? Put simply, which delay impacted the program first? In my first situation, the employer's event impacted the program first, and hence they own the float. In my second situation, it was the contractors. So who owns the float? Whoever uses it first. What this also shows is the importance of when the delay impacts the program. The general rule is, there are some slight exceptions, but when you're dealing with concurrent delays, they are not concurrent if they do not impact the program at the same time. A concurrent delay is this. Today, there is a hurricane going through our site, which is not something we would have expected, and hence it is a delaying event. Today, the contractor has no labour resources on site, therefore could not carry out any works. Nothing to do with the hurricane, it's just everybody's off. And today we have a complete lack of information, so even if people were on site and the weather would allow, we wouldn't have done any works at all. So we have 3 events all impacting the program. Under English law, the contractor would be entitled to a full extension of time. Under Scottish law, there is a potential for apportioning the extension of time based upon what the courts consider is the most critical delay. But under English law, they would be entitled to a full extension of time, but no loss and expense. But that is in the case of concurrent delays. But if we find that, as a matter of fact, the weather happened today, but the lack of resources was a problem that happened a week ago, they are not concurrent delays because one happened earlier. It is their effects that are concurrent, and that generally the event that happens first is determined to be the dominant delay. And I would refer you to a saga case which concerns a ship, where they determined that where there were pre-existing delays for which the contractor was responsible, and thereafter there were employers' delays, the contractor was not entitled to an extension of time for any of the employer's delays because they were subsumed by the earlier delay for which the contractor was responsible. What we can again show is the importance of the program, when the delays impacted their program and what was their effect. Now, for those of you who maybe listened to me speak with a number of my colleagues last week in the construction roundup, you would have heard me being somewhat critical about the notice of extensions of time issued by contractors. I found that contractors, when they issue extensions of time, generally go through the same wording, which quite often starts, "We hereby give notice." They don't normally use the term hereby, but when they suddenly start to write extension of time notices, they use the word hereby. We hereby give notice that the regular progress of the works is likely to be delayed by certain relevant events. We cannot at the moment assess the period of delay. We confirm that we use our best endeavours to mitigate delay, and whilst writing, we also claim loss and expense. Is that a good notice? The answer is no. As a general rule, when I get involved in very, very big extension of time claims and I go down to site and speak to the people on site about the delays, I always ask them, what's the problem? And more often than not, I get the same response. I don't know, mate, I've only just joined. Unlike when I was in construction, there was nothing more that I liked than a big old extension of time and an argument. It was great, but most people don't like that. They're not like me. And where jobs go wrong, more often than not, people leave rather than be involved in what is a big dispute. The next thing is that when you're in a dispute, more often than not, you are trying to allege that the other party is responsible. Now, quite often those that are the contractors that say, for example, who claim an extension of time, say, well, we don't need to issue all this information because the architect knows he's the one who's responsible. Well, that may be the case, but if he is responsible, he's likely not to want to accept it. So therefore, in reality, you need to provide even more information. So, in a simple view, what I would suggest is that when you produce an extension of time notice or a claim subsequently, you should be considering that you're issuing it to your mum, that your mum has never been on site and doesn't know anything about the job. And you should be able to give her a letter and says, here it is. And she should say, I can fully understand. I understand that it's an issue concerning late information. I understand when you originally needed it. I understand when you actually obtained it. I understand by the late date you obtained it, why it caused you a delay. And I understand what that delay was and how long for. It should all be able to be determined in that notice. If it doesn't meet those requirements, then to me, it isn't good enough. Now, what quite often is argued to me is, well, we don't actually know. Well, that's fine. You simply put in the notice is our current assessment is as follows. We currently assess that it's being 3 weeks, but that's based upon you issuing the information tomorrow and that us being able to carry out the work as per the programme that we've put forward. You then don't get the information when anticipated, so you send a further notice. We advise we still haven't got this information. Our revised assessment for the delay is now 6 weeks. You then get the information. You then say we have now received the information. And whilst we forecast the delay was 6 weeks, it's now 7 weeks because having reviewed your instructions, the implications of this instruction is as follows. This is, however, based upon us being able to do this, this, and this. What you then do is to send a new one saying our anticipated 6 weeks has actually proved to be 8 weeks because of this, which could not be avoided. By issuing this whole chain of correspondence very much supports your case and would be far better for an expert to use than no notices at all, or one saying we'll let you know later on. Now, what we've identified is the level of information that can be issued. But the question is in what format must be issued? And as is always the case when asking this nature of questions, is it depends upon the contract. Now, the contract provides that you have to issue notices, be it JCT, NEC, PC, GC works. Why are you having to issue these? Well, I like the NEC because it's saying why. It's saying you've got to issue an early warning. What your extension of time notice is meant to be doing is warning the employer. It is meant to be giving the employer the opportunity to mitigate that delay, to try and avoid it, by example, issuing the relevant information that's outstanding. So you have to follow that contract provision. Most contracts provide in what format they may be issued. Under the JCT, there is provision for saying that it has to be in writing or that it can be issued by email. Under the NEC, it says it must be in a form that can be read, copied, and recorded, and hence would include emails. So far as the content, you're meant to be saying what was the event, what was the effect, and what was the delay ultimately to completion. Well, put simply, your progress reports could do that, provided you issue them by post or fax or email. They show what is the delay. So you could put at the bottom, activity 3 is in delay by 2 weeks because of outstanding information. You've now stated the event which is causing delay and what activities are being affected. You've also shown the end date going out, which is showing the delay to completion. It's a compliant notice. And indeed, it may be a notice that no one is even going to review, get upset with, or otherwise. So using the program as an extension of time notice is an extremely good way of dealing with delay and properly satisfying the contract obligations. As you would have seen from my CV at the beginning, I have acted as an expert in programming and planning in delay claims. I'm also a panel adjudicator on the RICS and CIR and other panels, and I often get claims for extension of time put before me. And when assessing an extension of time, an entitlement bait is not necessarily based upon the truth, it is based upon the records. If you're an expert witness, you can only rely upon the records before you. If the records show one thing and an employer says, well, that's not true, or the contract says not true, it's very difficult for you as an expert to go against the records. So the records will generally show what the true entitlement to extension of time is. Indeed, I've acted for an employer where our defence to a contractor's extension of time claim was their own records. They'd produced a claim narrative and an assessment, and we showed that this assessment was purely theoretical and untrue. And we showed that by their own progress reports, it was different activities were the critical delay and which ultimately delayed completion. And I've done the reverse. Where a contractor has had no records of an extension of time, I've identified from progress reports produced by the employer as part of site meeting minutes that those record what were the delays and use that as the very basis of an extension of time. That raises a further issue. Are extension of time notices a condition precedent to entitlement? In other words, if you fail to issue an extension of time notice, are you still entitled to an extension of time? And I've already given the answer. It depends upon the contract. If one looks at the NEC, it says that if the contractor fails to issue a compensation event notice within a set period of time of when it was aware or should have been aware, it has no entitlement. There is, however, one caveat. It says where the project manager should have awarded or issued a compensation event notice, the contractor still has an entitlement. So that situation shows that where there is a change to the works information, the project manager should have awarded or should have issued a compensation event notice. And therefore, if the contractor and the project manager fails to do so, the contractor still has an entitlement to extension of time and for loss and expense under the assessment of a compensation event. Indeed, there is a very interesting case concerning the Northern Ireland Health Executive, concerning that very issue. It went through a number of court cases, and the court said that where there was a failure to issue a compensation event notice, the contractor was still entitled to an extension of time where the PM had not done so, and it included that that instruction could come from project meeting minutes. I hasten to add this was all following an adjudicator's decision, namely mine, and the courts thankfully agreed with everything I had done. Now, one thing that's important is looking at how the delay is to be assessed, because we have a complete different means of assessment under the JCT when compared with the NEC. JCT traditionally, and like most other contracts, provides that the delay or the entitlement to extension of time is based upon what is the actual delay to the contract. In other words, you are quite often going to look retrospectively and see what is the ultimate delay caused to the completion. If there is no delay, then there is no entitlement. Under NEC, the situation is completely different. We're basing it upon the accepted program. And what we do is we compare the last accepted program to the current accepted program, which shows the delay event. So if the contractor was if the contractor was likely to complete their works 2 weeks early in accordance with the last accepted program, and today there is a delay event which causes a 2 weeks delay, the difference between the programs is 2 weeks. The contractor is entitled to an extension of time of 2 weeks, notwithstanding there is actually no delay to the completion. Under the JCT, the contractor would be entitled to no extension of time. Now, this is quite often the most common situation when there is delay. Contractors produce what is known as a global claim or a rolled up claim. They do this both in regards to relevant events, delay events, and in regards to the recovery of money. Let's first of all address NEC. You cannot do it under NEC. I've had no end of contractors coming to me with these global claims under an NEC, and they will simply fail because NEC doesn't have provisions for extension of time and loss and expense like the JCT. Rather, it only has compensation events. And for each compensation event, you have to value the variation, if there's a variation. You need to assess the loss and expense and the extension of time and allocate it to that event. You cannot have a global claim. If you run a global claim under the NEC, you will fail. However, under JCT, quite often, as I've said throughout this seminar, the situation is different. The courts have said you can have a global claim. So a global claim is like this. We were meant to finish in January. We finished in December. There were 20 events. These are the 20 events. We therefore claim the 52 weeks, and our additional cost is £1 million. What you cannot do is identify what events cause what delay or what events entitle you to what additional monies. This is quite often how contractors produce their claims. Sometimes they may actually identify the relevant events and say there's 3 weeks for this one, 4 weeks for that one, 6 weeks for that one. But then they simply say the total delay to the job is 30 weeks, and this is the total amount of money we are claiming. That is a global claim. Now, the problem with global claims is it effectively reverses the burden of proof. Normally, the burden of proof of proving your loss, proving your entitlement, is placed firmly with the contractor. He who asserts must prove. So the contractor has the obligation of proving they're being delayed and for how long, and for proving what the loss and expense for each event is. But the global claim is being produced by the contractor who's failed to do this necessary action. They've failed to fully address cause and effect. And what the employer now has to do is disprove it. And this seems very harsh on employers. Now, the case that dealt with global claims is Walter Lilly. And I would advise you to read the case judgment on this because they quote a number of statements made by Mr. McKay. He apparently, from what I read, said some very strange statements that came back to bite him. Now, surprisingly, although everybody uses this case when dealing with global claims, the court actually decided that Walter Lilly's claim as advanced was not global. What they had done was they had identified what were the relevant events, what was the delay for each and every event, and what was the cost applicable and sought for each separate event separately. And hence their claim was not global at all. However, the court gave very helpful guidance on global claims, which was what had been alleged by the defendant. And what they said is that for global claims, the contractor has to demonstrate on the balance of probabilities, in other words, more than 50%, that A, an event actually occurred which caused the delay and which entitles the contractor to loss and expense. B, that those events, which they're claiming, actually did cause delay and disruption, and that what was the delay and disruption so caused. So they had to tick those three boxes. But they went on and they said that this, however, will depend upon the contract. So if one goes back to the NEC, the global claim would still not satisfy, would still be unsuccessful, even if those 3 points were met, because they haven't met the contractual obligations. Contractual obligation says global claims cannot be advanced. So similarly under JCT, if you're fed up of receiving these global claims for contractors, it's very easy to get rid of them. And that is by adding bespoke clauses into the JCT that says what the contractor has to do when producing a claim, either for extension of time and loss and expense. And if you say they've got to show cause and effect, then that's what they've got to do. And if they don't meet that obligation, then their claim must fail. So far as the evidence is supplied, in the case of Walter Lilly, the court said it is completely dependent upon the contractor as to what records they produce. The nature of the records will simply go to the weight. In other words, to what extent will they be believed? It's my experience that quite often the contractor will say that it's white and the employer will say it's black. And if I'm the adjudicator or arbitrator, I don't know which one is right. And as I've mentioned, it is on the contractor to meet the burden of proof, and they haven't because it's 50-50. They've got to get to 51%. But ultimately, the form that the evidence can take is completely at the discretion of the contractor. But as I mentioned, the best thing would be to use progress reports supported by photographs. One of the problems, however, recognised by the court in Walter Lilly is the evidential difficulties caused by claims that are advanced in the form of a global claim. And there are two things that you can use to effectively undermine a global claim. Number one is that the loss has not been caused by the events upon which the contractor relies, but rather has been caused by the contractor's underpricing. So when producing a global claim, what you must show is if there had been no delays, what your cost would have been, because that's your baseline. If it can be shown that you underpriced your tender, and what you've done is then to say, this is my tender price, this is my actual cost, one from the other is what I'm seeking, you're claiming for amounts that were not losses caused by the events, but they are losses caused by your underpricing. The second thing is if you can show that there are certain events or factors which is the reason that caused the contractor to incur part of the loss, and which are not the events. So let's just say, for example, we can identify that there were 10 events but we identify one of those events doesn't give the contractor loss and expense, it might give them extension of time, or one of those events doesn't give them extension of time or loss and expense at all. What we have then is 10 events, and let's just say there's £1 million claim, but one of the events doesn't give the contractor either time or money. How do we pull out the amount that's attributable to that one event? And if we can't do that, the whole claim fails. And I've seen this time and time again. A contractor's put together a claim, and there is no doubt they have been delayed. And there is no doubt whatsoever that they're entitled to loss and expense. But the problem is, we can't determine what that exact loss and expense is because part of the money sought are not recoverable. And if we can't take out that element which is non-recoverable, the whole lot goes. One thing is that the courts have identified that there is no problem in advancing global claims, but they will be sceptical about a contractor's global claim if the contractor could have proved it, but has simply chosen not to. And as advised in the Society of Construction Delay Protocol, as I just said to you, where an adjudicated judge arbitrator is unable to assess the element that is non-recoverable within a global claim, then the contractor will fail. And unfortunately, to their cost, some referring parties where I've been an adjudicator, where I've had tremendous sympathy for their claim, I've nevertheless been forced to award them nothing because I cannot work out what their entitlement is because of the format the global claim is produced. Okay, I've covered a large amount of information within a relatively short period of time. I imagine there might be a question or two. Julie?
There are indeed some questions, Richard. First question up. If the NEC engineer should have issued a compensation event, for example, due to a delayed access linked to a third party, but failed to do so, is there a requirement for the contractor to have notified a compensation event within specified timescales in order to establish entitlement to EOT/loss and expense?
Really simple, yes. The situation is we have loads and loads of compensation events against various events. We have compensation events that deal with late access, effectively exceptionally adverse weather conditions, ground conditions which are unforeseen, the late issues of tests, late issues of information, something that neither party were aware of at the time of entering the contract and which neither party could avoid. And the list goes on. With the exception of changes to the works information, if the project manager does not issue an early warning notice and a compensation event notice, the contractor should. And if the contractor does not issue a compensation event notice, they lose all their entitlement. If they don't issue an early warning notice, their entitlement may be reduced to the extent that if they'd issued an early warning notice, the delay or the cost could have been mitigated. The only one where a contractor would not lose their entitlement is changes to the works information. So I go a step further. Be aware, project managers under the main contractor, under the main contract, and under the subcontract, the contractor, should be issuing for each and every instruction an early warning notice and a compensation event notice. But equally, every time there is what you believe to be exceptionally adverse weather conditions, late access, or anything like that, a contractor should be issuing a compensation event and an early warning notice. Now, this creates huge amounts of paperwork. Now, whilst the contract may not provide for it, I think it is not unreasonable for you to issue at the end of every, let's say, week or 2 week, a whole list of what you think may be compensation events, and that you also say this is an early warning notice. This, I suggest, is the minimum that you should be doing.
Okay. A couple of other questions here. Dealing with works packages, extension of time claims as part of the JCT MC contract effectively, when exactly does the time start ticking for the 12 weeks to review? And how formal does a notice of this kind have to be, for example?
Okay, under JCT main contracts, we have a period of 12 weeks for the project manager, the architect, the CA to assess extensions of time. And it runs from the date of the notice, or if later, receipt of sufficient information. However, where that notice of sufficient information, the period to the date set for completion is less than 12 weeks, the employer then only has to the date that completion should be met. I'm aware that when notices are issued, quite often the CAPM asks for more and more information and thereby seeks to delay this process. And it's quite often asked, what can the contractor do? Answer is not a lot, other than to go to adjudication. But basically, the 12 weeks runs from the date of the notice, or if later, the receipt of sufficient information.
Okay. Can you shed some light on the impact of prelim thickening when dealing with delays?
Okay, preliminary thickening. When a job is delayed, we can effectively break down the losses that could be incurred by a contractor into two forms. Those associated with the job being prolonged. So we've got a job that's going to be on site for an extra 5 weeks. And because of that, we're now going to have our site agent and our site huts on site for an additional 5 weeks. It's obvious. Now, when you're claiming those costs, it's not uncommon for the contractor to simply claim the period for the extra 5 weeks. That is in fact wrong. You should be claiming your prolongation cost, let's say, let's use that term, for when the delay is caused. So let's give you an example. We are meant to start site today, we're all set up, but for whatever reason, we can't start because of a problem which entitles us to both extensions of time and loss and expense. I've got all my demolition crew on site. I've got all of my excavators on site, and they're all sitting there doing nothing, drinking coffee in the cafe. My loss is being incurred today. It is today that I can recover those costs. Now, the job finishes because of this 1 week delay, 1 week late. Now, during the last week of the contract, I don't have any of those resources on site. All I've got is my finishing foreman. What is my loss? It isn't the cost of the finishing foreman. It is the cost associated with the delay that occurred at the time. Now, if we adhere that approach, there isn't actually a separation between thickening costs and prolongation costs, because if we say that on week 1 there was this delay, but the delay resulted in me having to bring on additional resources to deal with this problem, I'm picking up those costs at the same time as the other costs. So the simple rule is what you should be doing is effectively starting off with your baseline program, which let's hope is achievable and which would have happened if there'd been no delays. And you cost that program. You show all the resources that would have been expended if the program had gone as planned. And what you'll start with is your tender breakdown. What you may then do is just recognize that your tender underpriced your prelims. And let's just say that you show that whilst you only allowed for half a QS, you actually needed a full-time QS. You therefore put down what were the resources that would have been expended had the job gone to plan. What you then do is to show your as-built program with what were the actual resources. You take one from another, and then I try to identify the additional resources expended, allocating to the relevant events. And so by doing, you will be picking up what is in theory, both your prolongation costs and thickening costs, and allocating to the event that has caused you to incur it.
Okay. Another question here. Would you prefer to bind a program into a contract or merely state dates or duration for the contractor to meet?
Well, it depends on what you're seeking to achieve. If you are seeking to impose those obligations upon the contractor, then it doesn't matter which you do, provided you do it properly. But the problem is if you include a program, unless you have bespoke provisions for what is called a bet and call program, the program will have no implications. It won't effectively bind the contractor to do it. So in simple terms, what you need to determine is A, what is it you are seeking to achieve? And then B, ensuring that your contract is properly drafted to achieve what you intend. What all too often happens is what the parties intend doesn't work. Let's just give you an example. As I've said, I'm an adjudicator and the parties have got a dispute. Party A says, we think it is white. Party B says, I think it is black. And they go to me. Now, what I've got to do is I've got to look at the contract, and I don't have to determine what was the party's intention was. I have to determine what a reasonable person, having the knowledge at the time the parties entered into the contract and looking at the terminology used in the contract, determine what a reasonable person would think was the case. The original statement was the reasonable person was the person on the on a London bus, omnibus. It's now the man on the tube. But I've got to determine what I think was their intention. Now, what is almost certainly going to happen is I'm going to think, I don't agree with either of you. What I think from the contract document is neither white nor black, it's red. And what I might actually determine, and what the courts often determine, is what the parties thought that they agreed isn't what they've agreed. They've agreed something completely different. And the cases are full of them. One prime example is a case concerning Mullally and Leander. Mullally included within their contract a document which was an activity schedule which included for dates for elements of the works to be completed. They believed that had contractual significance and that the contractor or subcontractor had to comply with it. The courts disagreed. They said you didn't have any such obligation because the contract was unclear and that the subcontractor simply had an obligation to complete by the completion date. So quite clearly what the contractor thought was the agreement wasn't. And it may have been that the subcontractor also thought that were the clause, but that's not what the court decided.
Okay, someone else is asking, if the contractors accept a low bid, which is less than estimated cost, how can he prove cost is due to the low bid price? Is that?
Oh, Jude, I can't quite hear you.
Sorry, someone's asking here, if the contractor accepts the low bid less than the estimated cost, how can he prove cost is due to a low bid price?
Well, it's really simple. We've got, the first thing is, if you've got a tender, I would always suggest as an employer, you should be seeking a tender breakdown, not least to show where the profit is. You know, contractors don't want to give you your breakdown because they don't want to show what they've priced. I've been involved in projects where contractors have actually underpriced the works and seeking to get it. So they actually lose money. So number one is you should be asking at the outset for a breakdown of the contractor's tender and particularly their preliminaries. What you'll then be able to do, and what the contractor has to do if they're going to produce a claim for loss and expense, is to show what their tender breakdown was. And they may show, for example, that their tender breakdown included for half a quantity of that. Yet on day one, for the first month when there were no delay events, there was a full-time QS on site. What we're showing is that the tender had under-allowed. As I said at the start, my background is in construction. I work for a main contractor that always only allowed for half a QS. And what was told when I very much started was, if you're a QS worth your salt, you should be able to recover half your cost. And therefore we don't allow for it. So in effect, from day one, the contractor has under-allowed for their preliminaries, they're under-allowing for the contract quantities allowing input, and therefore you should be able to establish that. So in very simple terms, if you're an employer, what you want is the breakdown to the original tender, which you need to scrutinise, and then look at the beginning of the project and throughout to see if what was tendered for and allowed for is actually what was allocated. And if not, why not?
Okay, we've got one last question here. Unforeseen events such as COVID-19 is being used on some projects to reclaim entitlements, but within these claims are hidden costs or extensions of time. We can see across industry, most projects suddenly require increased budget and years on a programme. Is the employer always liable? What is reasonable? The first lockdown occurred in March 20, but by July, August, 2020, a lot of sites had reopened.
Okay, a lot of points here. Number one is the employer always responsible? No. It will depend upon the contract. A common answer today. So number one is, who is responsible for COVID? Is it the employer's fault? The answer is no. It is what is called a neutral event. So what we have to look at is who is responsible in circumstances of this nature. It's like the weather. If we have a hurricane, you can hardly go to the employer and say, well, look, it's your fault for that. It isn't. And it will depend upon the contract who puts a party at risk. So let's deal with the weather. If there's a hurricane, under the JCT, it's exceptionally adverse weather conditions. The contractor is entitled to an extension of time, but not loss and expense. If we look at the NEC, however, we again have a provision for a compensation event for exceptionally adverse weather conditions, but the employer has a culpability for both time and money. So we can see under the JCT, the contractor will get time but no money. Under the NEC, they will get time and money. And COVID is the same. It depends upon what the contract says. Now, under JCT, if there is a claim, it will be one for force majeure. And under the JCT, for force majeure, they can get time, no money. Under NEC, it's most likely to be an event of 19, which is that neither party knew of at the time the contract was entered into, and that neither party could basically avoid. And therefore, under the NEC, they will get time and money. So under the question put, is the employer always responsible? No. What is the entitlement? It depends upon the contract. And we'll also, if we're looking at force majeure, it can't be force majeure if you enter into a contract today because you were aware of COVID. So it wouldn't fall within the remit of a force majeure.
Okay, thank you very much. That seems to wrap up the questions for today. So thank you very much for your time, as always, Richard, very much appreciated. And thank you everyone for attending. Our next events, next week we have two. We have Connor in the morning at 8 a.m. with his QS series, a new title, Named versus Nominated. And then in the evening, Richard returns with the latest in his Construction Essentials series, Loss, Expense and Damages. He's going into more details on that. So if you'd like a place for either or indeed both of these seminars, simply email seminars@silverllp.com. And as always, if you would like to ask Richard something specific but don't want to do it in an open forum, it's richardsilver@silverllp.com. Okay, everybody, I hope you all have a good day. Richard, thank you very much. We'll see you again soon. And thank you all for joining us.
Thank you. Bye-bye.